Welcome to today's program titled Compliance Chatter Virtual Meetings January Session. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the program by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE or SHRM credit for this webinar, a CLE and SHRM attendance verification code will be read later in the presentation. Please write these codes down as they will not be reread and they are required on the credit request forms. During this presentation, you will see a slide with the QR code that you may scan to access and submit your request for CLE or SHRM credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Masa Ali-Asghari. Masa, please go ahead.
Thank you very much, Donna. Welcome to everyone who has taken time to join us today. We look forward to starting a conversation with everyone on compliance in the immigration space, what it means for you, your employees, and your organizations. And we'll start with kind of introductions. My name is Masa Ali-Asghari. I am a partner at Seyfarth in the Immigration Practice Group. I'm based out of our LA office. I've been in the immigration space for about almost 25 years, so quite a while. And I do work on the benefit side, the standard visa sponsorships side of the immigration space, but I also have background and experience on the compliance side with I-9s, audits, investigations, Department of Labor, investigations as well in relation to H-1Bs and labor condition applications. I'm going to turn over to Dawn for introductions.
Well, thank you. My name is Dawn Laurie. I lead the immigration compliance practice here out of Washington, D.C., out of Seyfarth's office. A little bit separated, but very much a part of our labor and employment, our immigration visa practice. My experience goes back over 3 decades. I basically live and breathe Form I-9, E-Verify, anything to do with investigations, as well as proactive advice and counsel. I've lived through everything from the initial INS deployment of the Form I-9 back in the late 80s, through the Bush administration, and again through Trump. So this is a really interesting and busy time for the practice, and we're really very fortunate to be able to have a lot of depth and breadth here at Seyfarth, including our partner, Liam Rodriguez. I'm going to turn this over to John Connolly, who I worked with when Mr. Connolly, I think we met post 9/11, I guess, right, with NSEER. So this, our relationship with Guidepost, before it was Guidepost, but with the folks over there, goes a long way back. John, give us a little bit of information about yourself.
Thank you, Dawn, and welcome everyone that took the time to join us today. Yeah, as Dawn says, I'm with Guidepost Solutions here in Washington, D.C. in their immigration practice. I've been with Guidepost about 10 years now. Prior to that, I had over 3 decades with the Department of Homeland Security, and the precursor to that with the Immigration Naturalization Service. I began, I began as an agent back in the 80s and worked my way up to being the deputy of Homeland Security Investigations prior to retiring. But as Dawn says, I've been working with Dawn in this field for a long time, and since I've left the government, working with Guidepost in the immigration compliance with several different clients and law firms throughout the nation.
Great, thank you. So, our hope is to keep this as an ongoing conversation. The size of today's webinar, and given the interest, unfortunately, this isn't going to be as engaging with the audience as we wanted to, but please do take time to send us your questions through the Q&A module, and we'll kind of provide additional context in future webinars, and definitely send some materials around to address a lot of the questions that we know are out there. Our agenda today really focuses on four key components. One is the H-1B modernization rule. Many of you do sponsor individuals in the H-1B category. The rule went into effect under the Biden administration as they were exiting. We're going to talk through the immigration enforcement actions, preparing for work site visits, and kind of round it out with the DOJ and what we expect to see in the next 4 years as they retool and focus on different areas for the next 4 years. To kind of start out on the H-1B modernization rule, many of you may be aware, again, as the Biden administration was rounding out and exiting, they did finally issue the H-1B modernization regulations. The regulations themselves actually were initially initiated under the Trump administration, so they do carry a lot of the similar thoughts and threads that they had originally intended in this modernization rule. And the key one right now is the fact that they're really focused on the integrity of the program and the integrity of visa sponsorships and the employment of those in those statuses. So what does that mean for us in this context? It means that we're seeing and will continue to see increased on-site visits by the fraud detection unit that is charged with these on-site visits to confirm the validity of the employment and the status of these individuals. So interestingly, even before the modernization rule was enacted, we had already started seeing an increase in these site visits. And it could have been site visits for H-1Bs, but also for L-1. So if you're an international organization and you're transferring personnel in and out of the U.S. in the L-1 category, we were also seeing site visits in that context as well. Dawn, I'm curious if you can share some of what you've been experiencing with clients kind of reaching out with some of these visits and what you're seeing.
Well, I think, again, even before the administration changed over, we were seeing an increase, and definitely our companies are concerned about that. The fact that the prior administration finalized the rule, I mean, there were a lot of things that we weren't happy about in the rule, but I think we'd rather have that than what it might be if it had not been finalized. So again, we're getting a lot of queries, especially on remote workers, which is nothing new, but we are seeing that. We're seeing where the officers do want to go out. They want to see the work site. They also want to, perhaps meet at the home location or somewhere near the home location. So I think there's just a general fear of what else is going to happen. So I think it's just the increase. That's my answer. Just more.
Yeah, and a lot of what and when they're coming on site, what they're asking about is, where is the person working? How are they working? They might be asking to speak to the person who actually signed.
Oh, I think we may have lost Massa there for a second, but I think what she was saying is they may want to speak.
Asking to.
So, Mike, if you could help us out there, I'm gonna, Massa, are you back? We had a little bit of a blip.
Yeah. Sorry,
Yeah.
I am here. Are you able to hear me?
Yeah, we are. You were just explaining how they might want to see the manager. They want to know the specifics of what was in the LCA. Go ahead. Maybe if we turn off the camera. All right, well, I'm going to continue. Asked if you can hear us. The next thing that we wanted to speak about was the mandates in the modernization rule and what we're seeing on the new Form I-129. So if you haven't looked at it, for those of you that either have consultants or staffing folks on your sites, there is now a new attestation that you're making when you sign the I-129, and we've actually, cut and pasted it up there for you all to take a look. Basically now, in addition to having to have the site visits done for your own employees, you may be contacted and you will have to agree if you want to continue to have an H-1B employee that's on your site from another company. You're going to have to agree to it. Now you can see where you'll see the yellow highlights. It talks about allowing access to USCIS access, their officers access, not only to your organization, to headquarters, to their satellite sites, where they're sent, along with the third-party work sites. So what we're seeing now is a discussion among those people that place or those people that receive H-1Bs. It was always important to ensure that your posting notices were done and that things were done accurately, but it's going to be more important now to continue with that. John, let's talk really quickly. One of the things that you and I have worked on over the years are some criminal investigations that had to have, that dealt with H-1Bs. Give us just a quick thing. Do you think we're going to see an increase with this administration?
Thanks, Don. Yeah, I do believe you will. I mean, during the previous administration and the previous Trump administration, we saw an increase in criminal investigations into, the use of H-1Bs and companies using L visas and the use of even visitor for business visas, and were they maintaining compliance with what those regulations are and keeping them all those parties separately. So we've seen them do those investigations, and some of those investigations stem from these FD&S visits, right? So the visits start out, FD&S will then turn it over to, their counterparts at DHS and Homeland Security Investigations, where they'll, look at everyone's, documentation to make sure that your H-1Bs is compliant, your Ls are compliant, and are you using H-1Bs to circumvent, those other requirements of the H and L visas. So I do think you'll see an increase in those.
Exactly. I agree. I absolutely agree. All right, Massa, if you can hear us, if you can move, perfect. Are you back online?
I am. Hopefully you can
Okay.
hear me.
We can. Go
Okay,
ahead.
wonderful. Sorry about that. So
Okay,
I'll
good.
stay off video just in case. So we'd like to move on, and John and Dawn, I'd really like to kind of focus in and talk about this past week, because a lot has happened in terms of enforcement actions and what we're seeing. Could you talk through like the numbers and what we're seeing and what we're expecting to see?
Sure. Well, I get my news from X. I put the screenshots. ICE has a nice X account, and they post every night at 12 midnight or a little bit after that. Actually, no, it was later than that last night because I was looking about 2 and they still hadn't posted. But they post the number of arrests and detainers. Just really quick, John, before I move on to the specifics, do you think those numbers are accurate?
Yeah, I think they're accurate as of midnight last night, shall we say, but I think you'll see those numbers shift as they go through, and you'll determine, how many people were detained and were they subsequently released because they were either, had, some legal documentation or some other status. So I think that eventually we'll see them, shift a little bit, probably not greatly, but you will see some.
Okay. All right. So I want to talk about.
So, really quickly, for context, what would you say the numbers, either Dawn or John, what would the numbers look like before January 20th on daily arrests?
They were much lower, but they were moving. I mean, the Biden administration, especially on removals, they were definitely, I don't have the numbers in front of me, but they, I think we forget they were doing a good number of removals. They just weren't doing it the way, which we're going to talk about now, the way they're doing it now. John, I don't know if you know the numbers offhand.
Yeah, I remember seeing something recently. I think it was like, say, a couple of hundred. It was in the,
Mhm.
Yeah.
a couple of hundred a day versus what they're doing.
So if we must have,
Yeah.
yeah, that's exactly. So what we're seeing now, I think that there's, especially because we know that some of these arrests or folks that are being detained may have happened in or around worksite. We're not seeing worksite right now. We are seeing the enforcement and removal operations, the folks that deal with, deportations. That's what we're seeing. Tom Homan, who is the border czar for the Trump administration, has been very clear that the focus is on removing individuals with criminal records, right? And he's talked about, if they encounter other folks, well, then that's collateral damage. There's been a lot in the press about securing the border. ensuring national security directives are followed. He has talked about undocumented workers committing, undocumented individuals committing crimes just by entering the country. But right now we are seeing folks that are known to ERO. They know where they are, they know where to pick them up. There's been a lot of rhetoric about sanctuary cities not cooperating. He has said it would be a lot safer for his agents if he could just go into the jails and pick these people up, but because he can't, he has to get them other places. So that's what we're seeing. We're not seeing global work site, right? And John, like to hear your comments. I know we talk daily on this, but I think people would be interested because even folks in the community, right? I mean, even other attorneys don't really understand. Go ahead.
No, you're exactly right. And I think, the thing to remember is that, most of these arrests or all of these arrests probably could have been done on January 19th as well, right? So these are people that either have orders of removal or have criminal convictions that make them subject to removal from the United States. So I think that, this is not that there's no new law or anything that has been passed, right? This is that these are the laws that have been in effect that this administration has brought to the forefront, right? Whereas previous administrations, including the prior Trump administration and administrations before that, were, not as focused, shall we say? Okay, so I think that the collateral damage piece is where I think because when somebody goes to as I've done this in my years past, you go to look for somebody and you end up talking to 5 other people at the same time, and then you have a conversation with them, and they determine that they're not authorized to be in the United States, and that's when they get arrested, and you may end up with the person that you started out looking for. So that's kind of where it is. But I think the key here is that that this is not new laws. This is something that could have happened prior to this administration taking office.
Right. And we did see, I mean, back your CEO at Guidepost, Julie Wood, directed ICE back under the Bush administration, and we did see a focus, especially on employers back then. Where it was very clear, the press was, talking about going after employers, their especially bad faith, egregious employers. So, I think it will turn to that. We will see this, but for shock and awe, we're looking at that. Massa, we can go to the next slide.
So yeah, so we have this context now of from several hundred to 1,000 plus. And as we're thinking about that, what is it that we should expect to see as we look ahead to the rest of 2025? What kind of policy shifts will impact what companies are seeing? And then where do we go from the initiative initially of the criminal individuals who are being targeted initially? Where do we go from there?
Yeah, I mean, John, you can take out your crystal ball. For me, I think we're going to continue to see these numbers. I don't think that they're going to let up on this. I think that there's still a lot of low-hanging fruit out there, and they're asking for more money, more resources. We know that just this past weekend that other agents outside of ERO were brought in. They are looking to partner with different state along with other federal agencies. And, we've seen cooperation, in New York, we saw the mayor talking about a particular action to pick up a specific criminal. So I think that's going to be for the next few months, we're going to see that. Now, whether or not we also move on, if there's manpower, and we'll talk a little bit about the different types of enforcement actions in a minute, there may be some early rollout of inspections of I-9s. But in terms of, the uncertainty right now, I think, most employers are concerned about their existing legal workforces, right? There is a question as to whether or not the DACA, the Dreamer program is going to be targeted again. There's already some questionable court decisions there. So there are a lot of folks that, that have work authorization based on DACA. The same thing for TPS. The Biden administration last month provided an extension for certain countries, but it's only limited. We don't know whether or not the next administration is going to extend anything. There's also the paroles. This just in the past few days, and again this morning, we are hearing that the administration is going to be ending the programs that we have with Cuba and Haiti, Nicaragua, Venezuela, and others. So it's going to be important to watch that. I don't know how that's going to, employers are, have called me last week. I don't think we have any employers that have large workforces in this area, but they said, well, what are we going to do if they're here illegally, but we have a valid work authorization? What are we going to do? And I'm just saying, rely on the documents right now for the I-9s. There's no instructions otherwise. An employer would not possibly know if somebody's work authorizations are so. Even if we looked at the category code and we knew what they came in under, we wouldn't know what country they were from. So I would be particularly careful about that and not make any rash decisions based on what we're hearing in the press.
So I know, Dawn, you talk about this first phase and then the next phase, and what does that look like from your perspective?
Yeah, so the phase right now that we're talking about is what we're hearing every day, and I particularly like watching. I'm not joking. I like watching the Dr. Phil. He did a ride along this weekend, and even before that, he had interviewed Tom Homan. So he does have access, and it's interesting to watch to see what happens when ERO and ICE agents go on site. I think it is very clear that their hands, they've talked about having the handcuffs come off, right? That they're, that they're moving forward and they're, cleaning up. But at the end of the day, there's still handcuffs. The handcuffs are logistics, are going to be limited by the money and the resources that they have. John, give me, just a little bit of background and maybe some inside baseball. I know things have changed. I haven't been in the agency, but some things never change. Money restrictions, for example.
Yeah, to your point, I mean, as you said, they say the handcuffs are off, but there are still, the budget for this year was passed a year ago, right? Or, I know it was passed as continuing resolutions, but that money, those budgets were set in place. I heard, recently I think it was this morning that, ICE right now is a $230 million shortfall, right? So I think, what's going to restrict them, I think Tom Homan himself has said it in some interviews that at the time, he says, I don't know how much money the government has because I'm not in the government yet. Now he's in the government, he'll know that. But, Tom's been doing this for 30 plus years. He knows what the limitations are. He knows that the money is going to be a problem. Where the administration comes up with that money, but those are going to be at some point, it's costly to remove individuals, right? So I do think they will continue to do it. At what pace? I'm not entirely sure, but I do think we'll see an uptick at least for the next several months as we go forward, which I think leads us to the next phase, which is, where do they go from there, right? And I think that's, kind of like what we're talking about, like the increase with, outside of, the operations they're doing right now.
That's right. That's right. Yeah, we can talk logistics, Matt. So go to the next slide. So I do think that at some point, whether or not, I don't know where exactly it's going to come, I know that we will start to see notices of inspection go out. So let's talk about what is a notice of inspection and what you can typically expect. So a notice of inspection is a notice to have your Forms I-9 reviewed by the government. Every employer has to complete a Form I-9 for any employee that was hired on November 7th, 1986, or after November 6th, 1986. And you must maintain your I-9s for all your active employees, and there's a retention period for terminated employees. ICE is allowed to ask for I-9s that are within the retention schedule. You have 3 days to present those I-9s, 3 days, all right? don't give up your 3 days. We're going to talk about that in a minute, but I want to keep reminding everyone about that. You can generally request an extension, and in all the years I've been doing this, we've always gotten reasonable extensions. Mr. Connolly, I think I've asked you for a few extensions over the years, and ICE has been, fairly reasonable. I don't know if that's going to be the case, so it is important to ensure that folks are ready, and that you are, taking a look at your I-9s, which we'll talk about how to prepare. In terms of additional things, I think folks are often surprised that in addition to the I-9s, individuals are asked, there's an administrative subpoena, and it's pretty much templated. It used to be that different offices provided different requests, but pretty much now it comes from headquarters, and it is a subpoena that asks for business information, asks for your corporate information, your ownership, your payroll records. It will also ask if you've received Social Security no matches, if you use staffing companies. It will ask for independent contractor information. So it really is a full laundry list. The one thing that I want to remind people is that the 3 days, it's an administrative subpoena, and you certainly can work with the government on that. You don't have to provide it within 3 days. John, do you want to talk a little bit about anything here?
Yeah. What I would just say, like the notice of inspection, as you said, Dawn, only is the request for the I-9s, okay? And because that form is restrictive as to what you can present for that, if someone comes in and asks you for all the other laundry list of stuff without that administrative subpoena, they must get the administrative subpoena. They cannot just with the notice of inspection ask you for that.
That's right.
Okay.
I don't think, I haven't seen in any of, the last big round of NOIs that we had, and we're going to call notices of inspection NOIs, you'll hear us refer, was right as COVID was hitting, right? So the last round that some of them are still sitting on my desk was in March of 2020. We've had a few after, but there were specific reasons that our companies or institutions or entities were why their I-9s were requested. But I think they normally do give that administrative subpoena, but I think that's really what really confuses people. They see the subpoena and they think, oh, I have to give this to you right away. So I think for the most part, we've provided what the government's wanted. If it's difficult or it's a heavy lift in collecting documents, we've worked out rolling productions. Sometimes we don't give them everything. Sometimes we'll negotiate the initial list, even for the I-9s, will include all the terminated I-9s within retention. And we often, depending upon the size of the work site, often can get a reduction there. So it's important to know that, you don't want to just be blindly turning over. Another point that I want to talk about here, because I think it's really important for companies as they prepare for these increased inspections, is if you use an electronic I-9 system, that the electronic I-9 system will, information on that will be requested in the inspection notice and in the subpoena, and we'll ask you for the proof that basically that the system meets the requirements of the electronic I-9 regulations. I can't tell you how many calls a week I spend with companies that don't realize that there are electronic I-9 regulations, and that the vendors that offer these products may not all be offering products that are in fact compliant with the rules. So the types of things that the government will ask for will include an audit trail, which is mandated by the regulations. They will ask for what's the equivalent, what I like to call a business package, to talk about how the I-9s are created, what type of security, what type of quality insurance practices are in there, what the system offers, what type of indexing. They're going to ask about information on the electronic signatures. Now, what I will say is under the prior administration, we did start to see certain special agent in charge offices, we call them SAC offices, become much more interested in electronic I-9s. And we did see, we had some cases where there were issues with the government basically saying I-9s were not created because the electronic system was not compliant. So I think that for everyone on this call that uses an electronic I-9 system, you need to go back and you need to figure out kind of, when did we choose this system? Did anyone diligence the system? Do we know it's compliant? do we have a representation that it's compliant? Should we have a discussion with the vendor? I think that is something that everybody should be doing.
And Don, sorry.
So-
Don, if I could just add to that too, and I think, Masa says it in the Q&A, the regulations is that every employer in the United States has to do I-9s. Okay, so if you get a notice of inspection, it does not mean that the government has any allegation that you're employing unauthorized individuals. They could just ask a company, do you have your I-9s, and do it that way. Now, having said that, I will also say that this is typically the first step in an HSI or ICE investigation, right? This is the first step they will do. If they do have allegations, they'll just see what the workforce looks like. So this is, so there's kind of two different things. You could just be, anybody has more than, you guys both know better than me, but I think it's more than one employee, right? So,
No,
that's
that's a great point, John. I mean, a lot of our companies, I'll call them clean companies. We don't have any issues with knowing undocumented workers. There's no reason for us to suspect that the policies and processes are good in that regard, but they may have what we call paperwork violations, and those can be substantive or technical. We decided not to go into this for this presentation because it is pretty complex the way ICE decides their fines, but they can be expensive. So at the end of the day, you could have a perfectly legal workforce and end up with a very expensive fine notification, which is often the case, right? So there are things that you all should be doing in terms of best practices for I-9s. Although this is not required, I do recommend that our companies copy documents. Document copies are not mandated by the regulations, but for the most part, there's many reasons why you would want a document copy. And if you're an E-Verify employer, you are mandated to copy List A documents anyway. So it is important. There are other things that you could be doing. I know everybody's scrambling to internal audit right now. A word of caution. If the same folks that did your I-9s and have been looking at your I-9s are the ones that doing your internal audit, it's probably an internal audit that you want to think twice about. We often will come in, and John works with us. We do a lot of work with guideposts. Oh, go ahead, Massa.
Sorry, I was just going to say, just in the interest of time, and we could probably spend the rest of the 30 minutes on I-9's notice of inspections, and there's in the Q&A, there's a question about kind of what happens if they're requesting all this and you have staffing companies or independent contractors on site, and that in itself is a whole separate webinar. And so we actually will be, this is a series, so we'll be touching on some of those more nuanced pieces of this in the future. But again, in the interest of time, I'm going to move us to the next part of this in terms of the types of visits and what we can expect to see. But there's also this focus on an individual. How is that different, and what would employers expect to see there if there is a specific interested person that ICE is coming in for?
Yeah, so that is the first type of visit would be the notice of inspection. So if ICE comes on, they will come on. There will be a special agent. They could mail you. And we did see, we have received notices of inspection by mail, but I believe that they'll be going out. They usually will go out, and they were going out in that last round. And they will go out and they will ask to speak to someone when they come on site, and they will hand the notice of inspection to that person. And again, we recommend that very little exchange is done. Before we move on to the individual, I do want to just mention quickly about the staffing companies. It is important, as a staffing company, if you're an end client, you're not going to have the I-9s or information on your staffing company employees, on staffing company's employees. And if you are a staffing company, you may have certain agreements. You may be requested by your end client to provide I-9s, another practice that we do not recommend. There are third-party audits that can be done and other things, and we will cover that in another webinar. So the second type of visit that we see is ICE coming on site to talk to or to pick up an individual. And I think, John, I'm gonna let you talk a little bit about when they come on. Are they what type of warrants would they have? We're hearing kind of stories of ICE coming in. I don't believe that we've seen worksite HSI go in as of yet in the past week or so to pick up people. I think that we've seen enforcement and removal, going in, but not as part of a work site action. In other words, where the employer is being targeted. So in this case, what would a visit look like where it's not necessarily HSI, but they're coming on site?
Yeah, so Don, to your point, what we've been seeing, and I would say in the last week or so, is that ERO is looking for a particular individual, and they have their intelligence. It's driven by what they know. They're looking for the person at their last known address, or where they used to work, or whichever information they have, right, on friends and family or relatives, whatever information that person might have provided in the past. So as you said, in the past week, what I've seen is, ERO and its other officers looking for an individual. They may go to a place of employment to look for that person, but they're not actually, enforcing a notice of inspection or some other type of warrant, which we'll get into in a little bit here, on the location, on the employment. But in those situations, they're looking for a particular person. They should obviously identify themselves as an officer, and I've done this hundreds and thousands of times myself. Identify themselves as an officer. They should be able to tell you what their administrative warrant, and let me back up. The judicial warrants, the judicial criminal warrants out of either federal court could be for a criminal violation, okay, of some type. They could have, taken them and got them, arrested and got them indicted for a particular crime violation, or the administrative warrants. And typically there's warrants of removal or there's warrants of arrest by ICE. What a warrant of arrest does for ICE is it says they have allegations. They believe the person to be, subject to removal from the United States, right? Unlawful. That could be that the person's been here with a green card or a permanent resident, and they have a drug conviction or some other type of conviction that would render them subject to removal. Okay, doesn't mean they've been ordered removed. It just means they've been subject to removal. So they would come in, excuse me, with that warrant. And in either case, typically what we would do is we would, try to get someone. If you're the person at the front door, you may want to tell them I need to talk to somebody, obviously a manager or someone to higher up, and that you want to be able to, control that situation. In other words, if there's somebody there and they're on that shift, you could ask them, can we do this a change of shift? Can you come back at, a different time so we don't have to upset the workforce or anything like that? Or that what I've had employers do in the past is have them bring the employee to me, okay? And bring them to me at HR or wherever they are, because again, those warrants don't give you the right to search the location. They give them the right to go on any public access areas of that facility, but they do not allow them to go into privately non-public areas. So again, to the extent that you can, cooperate with them or whatever you want to do, and then you can, to the extent to control the situation, because the officer, if he's just looking for a particular person, is going to want that particular person.
That's right. And we're going to talk about planning in a minute. Let's go on to the third type of action, which is, they don't call them raids. Maybe they're going to call them raids again. I don't know. We're seeing a lot of changes, including on your Form I-9, where the prior administration changed the word alien to non-citizen authorized to work. Now it's being changed back. I don't know if you've seen that on the USCIS websites. So that's pretty interesting. Maybe we're going to call them raids again, but they're called worksite enforcement actions. And that's where the special agents and all their friends at other agencies, John, who used to come? I mean, I would see everything from OSHA, sometimes the FBI, the local sheriff, who else?
Yeah, you would have all sorts of, law enforcement support. And a lot of times that was for public safety, right? So if you're going to, block traffic, or the operation covers several, in some of these larger worksite operations, it covers several acres, right? And there's back roads, back entrances. You have, trucks coming and going, you have machinery that's being done, all sorts of things like that. So you'd bring in different people to, assess that. I mean, Don, you and I have talked about this. In the years past, we've done this. When you're bringing in, a caravan of vehicles, depending on where you are in the world, they see you coming. They know you're coming. I mean, one of the last places I walked into with the search warrant, the gentleman said, I saw you coming for 10 minutes, because you could look out across.
While you're watching on the prairie, right?
Watching the prairie as he's coming through. So I think, one thing I will say, is that whatever your position is, that when these officers arrive, be cooperative. And that's not the time to have the debate with them about what the policy is or what it isn't, right? And things like that. they have a job to do. The men and women of ICE have a job to do, and that's what they are doing. Okay, I think as I said earlier, the laws have been on the books for several years. It's not like these are new laws that came out yesterday. These are things that have been on the books. So, but I think when people show up, they're going to show up. More than likely with operations that large, they'll have a search warrant that allows them access to the property. Okay, to the extent that they will probably, for lack of a better term, surround the location. Okay, so they'll have officers on all sides of it, and then they will go methodically through the site. Okay, most of them, what I have done in the past is if there's machinery that's running, if it's possible to shut down the machinery, you have that done so nobody gets hurt. There's been incidents where people have tools and other equipment that they use daily that could be of danger to these officers, whether they're knives or hammers or whatever they are. Okay, so we would ask, people to, to the extent that they can, control that situation, and try to do it with as little chaos as possible. So we try to, everybody, if we cooperate and things like that.
And I think that is important for these worksite enforcement actions. I cannot remember one where they were not coming on with the criminal arrest warrants and with proper search warrants. Now, again, and we're going to talk about the plans. Messa, maybe you go on to the next slide. I mean, there's when
Yeah, just really quickly, I wonder if either one of you could talk to, if you have sensitive locations, and how do you handle that, if any different than other?
So there's been a sensitive location policy on the books since 2011. It was respected under the prior Trump administration, and it was updated under Obama in 2021. And basically what that says is that sensitive locations such as hospitals, schools, universities, shelters, nonprofits, religious institutions, churches, we're basically I don't want to say totally hands off because there were exceptions. If you had a dangerous criminal, you had someone of national security, there was a process that was outlined where individual officers needed to, agents needed to receive permission to walk into one of these locations. So it was not a place that people felt uncomfortable. If you went to church on Sunday, you were not expecting ICE to walk in. What we've heard from Mr. Homan and others is, the policy has been rescinded. There's been nothing replaced in it yet. Although in different interviews that I've watched with him, he's mentioned several times of a process still being there. Like I think that the directive, I have no idea, but I think that the directive to the agents has been, if you are going into these, you pretty much should go up the chain. So I think that, and John, you can comment on that, but I think for the first time, we have a lot of healthcare systems and hospitals and schools that are very concerned. They're concerned about their own populations, and they're concerned about, what ICE may or may not do. So there's a lot of things that we can do for planning. There's a lot of good resources and materials out there. But John, let me know what you're thinking, because this is a very hot topic right now.
Yeah, it definitely is. And I think you hit the nail on the head when you talk about, it still would go up the chain, because even prior to 2011, there was, while there was no written policy, there still was, if your only alternative was to, go to a school or go to the church to try to apprehend somebody, typically that had to be reviewed by several levels of supervision locally, just to determine, is there any other options you could do? And to be quite honest with you, common sense typically prevailed, where it would be, there's got to be somewhere else we can find this person, right, to doing this. So I think even if you could, with the sensitive locations, I think even without the written policy, like you said, I do think there still be some level of review, because no manager, right, if you're running the office, wants to find out that your agents went some sensitive location without their knowledge.
I think, and I don't think anybody in the administration wants to read about that either. So I do think they're still going to go up the chain. They're going to ask. But look, there is this, sense of shock and awe, and there's a lot of rumors going out. We have heard of agents coming to like a school parking lot to pick up somebody. I would hope that that, as you said, there are other locations. So this is something that we're watching carefully. So in terms of what companies can do, right? It's super important to ensure that everybody is thinking about what kind of plan you can have. There's a lot of information out on the internet. If you go into our blog site, bigimmigrationlawblog.com, we have several articles where we talk about, the specifics of putting a plan together. That said, and there are plans you can find on the internet. I think it's important for every company or institution or entity to take a look and to make sure that it makes sense for what their process is and what they have, because it's not going to be one size fits all. You can have general instructions. It's going to be super important to ensure that folks are comfortable and that they know what to do. People get nervous. I can think of several times over the years where just for a Form I-9 inspection, where you're given the 3 days, where I've had to go to ICE to ask for copies of my own client's I-9s because somebody was overzealous and over anxious, and they said, "Oh, we have the I-9s right here. We do everything right. Here's the box." And they literally hand it over. So those are the kind of things that we want to make sure. We want people to know, what they should be saying, what they should be asking for. Their staff, should be trained. We want to ensure that nobody is turning over documents unless there is a specific search warrant that is requesting that, and that is properly signed. You don't want to give any more information that is not asked. If anything is going, and again, it's a little bit different. Like John said, if they're coming in with a search warrant and they're handing it, they're going to typically look for the most senior person on the site. They're going to present it to them, and then they're going to move forward, right? A little bit different than if they're just coming in to look for someone. At that point, one of the things that we are asking for folks to do would be to have that plan. In terms of the NOIs, like I said, don't turn over those materials before the 3 days. It's not something that you want to do by yourself. Go ahead and retain counsel. Make sure that counsel has experience in Form I-9s and not just a light experience, because I think that there's going to be a lot of high stakes here, and it's going to be a little bit different than in years past. Like I said, you're going to have an administrative subpoena. You may not have to give everything. All right, next slide. Let's talk about assessing. So John, when you're the agent, you're coming on, what are you presenting? Like what are folks supposed to be looking at? Because I think that's some of the questions. What are we looking at? Should we be asking for their badge? What's that first point of contact? Just kind of walk us through, if you don't mind, just some of your experiences, because I'm always there afterwards.
Right. Sure. So, and most of this will cover almost all the scenarios, but, obviously, like you said, it's different when they're coming in with a subpoena versus coming in with a criminal search warrant, right? But in any situation, whether they're wearing, jackets or shirts that have, what agency they work for, you can ask the individual, the person that seems to be in charge, or any of them, actually, you can ask them to produce identification, right, as to who they are, to verify their identity, that they are who they say they are, right? So that you can, so they'll be able to show you, all of them carry credentials with their picture on it and what agency they work for. Okay. If you can get a business card from somebody, I would ask if you can get a business card from them, because then you have all that contact information. What you cannot do or should not do, and the agent will refuse you cannot make copies of their identification. Okay. We're not allowed to make copies of their identifications and things like that. So do not ask them to take them and make copies of them. The agent will not let them out of his or her hand. I'll tell you that right now. Okay. But when they come in, like you said earlier, you have a plan of what you're going to need to do, because it can be intimidating, right? And things like that. So when you come in, you might have 1 or 2 people in your lobby, depending on what they're doing, that person knows what to do. That's not the time to learn what they want to do. But when they come in, they typically will tell you, we have, we want to issue a notice of inspection and an administrative subpoena. They'll probably ask for somebody at HR, because they know that's where they need to go, right? Leaving it with the person at the front door is probably not going to be sufficient.
John, what if you were coming in not for a notice of inspection? Because I think, then they might be bringing in the auditor, the agent, they're coming in, they like to maybe remind everyone that they're agents, and they, kind of push back their jackets and show their guns. I've seen that. But let's say you're actually coming in for a worksite action. Are you still stopping?
You typically would stop and ask them to speak to the person in charge of, if it's, let's just take a location, say it's a plant, right? you would ask for the manager, the senior person that's on site, okay? So you can serve that judicial warrant too.
And I think it's important to know that the senior manager may not be on site because oftentimes you are coming in between shifts. Like if it's a 24-hour plant, you're coming between last shift coming and the morning shift coming in, and maybe the plant manager's not there yet. So everybody should have a role, from the receptionist. There may not be a receptionist at 6 a.m. when that shift cuts. So you don't want just your senior managers. You want to have your managers, your shift managers, HR representatives. Everybody should know what and some of the guidance is practically going to be duplicative because you may not have folks on site. So think about what kind of business you are and what the practicality is. It's super interesting because some of the calls that I'm getting that I've gotten for the past few weeks are from companies that it's highly unlikely that there's going to be a worksite action. I'm never going to say never, and again, some of my folks in the financial institutions or whatnot in technology, there could be a national security issue that you may not be aware of. In that case, generally speaking, we'll usually see some reach out from the agencies. But if we're talking just a straight worksite raid, everybody should have their actions, and they should be requesting documents. And like you said, you're not going to be able to copy. If things are going out, I want to remind everyone, to the extent that you can ask for a copy, that's great, but usually you're not stopping to allow people to make copies of the things that you're bundling up and putting into boxes in my experience. So your folks do need to be able to review as part of that process that you are going to make sure is written. And by the way, a 15-page, what to do in the event is not going to help your people. Like, you need to have like a short job aid, which is, you can have several pages, but then you need to make sure that they understand what their points and what their duties are. So maybe a training to go over it, because people are going to be nervous, right? ICE is sitting in front of them, and it's very nerve-wracking. They need to know exactly what they need to do and when they need to do it. We're going to come back to some things, but let's talk about the differences in the warrants. So John, a judicial warrant, and you'll see we can flip over to show what on the next slide what a judicial warrant looks like. Next one, sorry. Right there, sorry. Judicial is going to be your second one right there. You see that? U.S. District Court. It's issued by a court. It's not issued by the Department of Homeland Security. You can go back. When we are dealing with the actual warrants, it's going to be very specific. A judge has reviewed it. You're asking. So John, tell us, about that. And also, let's also talk about getting a warrant is not easy. Like a worksite action, what I've been saying to everyone is we're not going to see a worksite action that would be started under this administration for many, many months, maybe even, 9 to 12 months, because it takes a long time for agents to put a case together. There could be something that might have been initiated under the Biden administration with their priorities in mind, which was labor exploitation, minor children working. So I could see something like that happening. I don't know, John, if you could, but walk us through how you get the warrants and what they're going to look like.
Right. So we'll go with the highest level of scrutiny. We'll leave it at that. Like the judicial warrants, like you say, they're reviewed and signed off by a federal magistrate, right? So a magistrate in the federal courts. And if it's for an arrest warrant, you have to document what your probable cause is, that what the violation that person had, and that you have probable cause to cause that arrest. If it's a search warrant, and let's take the worksite, example, it has to document what the agency's probable cause is. They have to do, it could be the results of an inspection. It could be results of, arrests not on the work site where people had fraudulent identities and they said, oh, I worked at XYZ place and things like that. So you have to build all that to show probable cause to the magistrate that you have a reason to believe that there's, persons unauthorized working at that location. Okay. But as you said, you just don't do that overnight. You just can't walk into a federal magistrate's office and say, can you sign this? Okay, this is what I want to do. So you've got to build that case. It's no different than building a case for a drug seizure, right? You have to build your case and things like that. So those situations are under the highest scrutiny of a federal magistrate, right? And I've seen federal magistrates that have, told me to come back, there wasn't enough, or they've actually, quoted other sections of law. They're actually handwritten on their warrants and what they've done. Okay, so they're very, they're a highest of scrutiny, right? And the U.S. Attorney's Office is involved because it's a criminal prosecution. So the U.S. Attorney will help you write that warrant and get it before the magistrate and things like that.
What
For
about
the
wait, before you go on that, what about a Blackie's warrant?
So
How involved?
Yeah, so a Blackie's warrant comes from Blackie's House of Beef versus Castillo, I think, from 1978. It was I believe it's a restaurant in DC, or it was a restaurant in DC. The Blackie's House of Beef warrant is a civil federal search warrant. Okay, so it is not a criminal search warrant; it's a civil federal search warrant that allows you to search for individuals. Okay, people that you believe. But again, it has the same level of scrutiny as the federal criminal warrant, because you have to show what the probable cause is to get that warrant. Okay, so why you believe there are unauthorized people working at that location. Okay, so it has that same level of scrutiny, but it's civil. Most people probably wouldn't know. You'll hear them refer to it as a Blackie's warrant. And again, it's based on the court case. And then moving on to the administrative warrants, when it's either a warrant for arrest or warrant for removal, those are actually signed in the agency, typically in the chain of command of the local office. So in other words, when I was a special agent in charge, I could sign warrants of arrests and things like that. I didn't work in ERO, so warrants of removal were differently signed, but they're not signed by a federal judge. They are signed by, now again, the officer has to show why they have a reason to believe that person is subject to removal and things like that. So that's what they do. So again, it's much less level of, but they still have to provide the information, a reasonable suspicion, shall we say, for that.
Super helpful. And then what about administrative warrants? Again, because lots of confusion. That's, on the Department of Homeland Security side. Do you see? I think right now that's what we're seeing. Most of the folks that
most of the what you probably see now with these people that have been ordered removed either have an order of removal, a warrant of removal, or they have an arrest warrant that somebody says this person was convicted of some crime that renders them subject to removal. So I think that's what you're seeing. Again, those are signed off on by someone in the agency and things like that. They don't give you any authority to search a house or a building or anything like that. They are just that. They have a warrant to, what it does is that the person being the agent has gone and built enough evidence to show, whether it's court records or things like that, to show that this person is subject to removal, or an immigration judge has ordered them removed and the warrant's been issued. And that's what we're seeing now. The other thing go ahead.
No, I was gonna say, I don't think we've seen documents being taken. I haven't heard anything about that, but that's the next thing, just to remind people that there's a difference between what, administratively they can ask for, which, like we talked about with the I-9 information, and then actually what you may have to challenge in court because somebody, has already looked to make sure that there's based on probable cause that there's a reason. So this is where we want to make sure everything is done correctly because we want to preserve the record. We may need to challenge something, but it is important to know the difference. And again, when you put together your processes and procedures, you're going to give a little bit of information with samples to your folks so that they can understand. You're going to have a process to call your in-house counsel if you have one, or have somebody on the outside. All right. In our last few minutes that we have, and John, I will leave a minute for you to just kind of wrap up. Massa, you want to just give an overview on our friends over at IAR, Department of Justice and Civil Rights?
Yeah, just to shift gears a little bit, really high level, we know that in the last few years, we've seen the Department of Justice really become more active in the immigration space, and in particular in relation to settlements that we've seen come through with high profile companies related to their perm practices. And that perm practices are it's a program where companies sponsor individuals for their green card, and it requires a test of the labor market market, with the Department of Labor regulations controlling that test of the labor market. So you'd ask, why is the Department of Justice involved if it's a Department of Labor program and regulation that's being followed? And the reason for that being that we are posting jobs in a recruitment type of manner, and we have to make sure that we are not limiting options for positions to U.S. workers. And that's how the Department of Justice has become involved. And we've seen high settlement amounts from organizations where the Department of Justice has determined that their actions have basically impacted the ability of U.S. workers to have positions available to them. And so while we might see the Department of Justice shift away in certain areas where we've seen under the Biden administration, in this context, we're expecting to see actually more involvement and more activity. And Dawn, you can talk a little bit about what we are seeing and expect to see in that area.
So right now, in the 1 minute that I have, this office has come under scrutiny because the whole Civil Rights Division, all of civil rights is being looked at. There was information this week where there were memos and guidance that have gone out that there are not supposed to be any settlements entered into, and that there should be no litigation filed. So we're watching that very, very carefully. That said, the Immigrant Employee Rights section of the Department of Labor, the Department of Justice is very much open for business, and they are still working through their cases. Companies should know that there's a lot of things to look at, that office is pretty much being blown up every which way, but I believe that they are going to survive. There's a lot of constitutional and administrative challenges to them, as well as the administrative court, the chief administrative hearing officer that takes on cases, either discrimination cases or the other cases that we just talked about, I-9 cases. So there's a lot going on there. Masika, ahead.
Sorry, we come to an end, I did want to share, as folks are dropping off, the CLE code for the program is S as in Seyfarth, S as in Seyfarth 1625, and the SHRM code is 25-P as in Peter, H as in Harry, W as in Walter 64, 25-PHW 64. Thanks, everyone.
Thank you.